So we've talked about bail and bond. That stuff all occurs in magistrate court?
Yes.
So what happens next?
So if you're able to post your bond and you bond out, your case is then what's called bound over. They send it over to the court of jurisdiction. So for misdemeanors, that's state court. For felonies, that's superior court. If you are not able to bond out, either because your bond is denied or you can't afford it, there's one more step in magistrate court, and that is for your preliminary hearing or committal hearing. And that is basically a hearing in front of the judge to make sure that there is probable cause to continue to hold you in custody while your case is pending.
Okay, so potentially, even if you can't post bail, there's a possibility that during a probable cause hearing they could say, well, there really wasn't enough probable cause to hold you in jail. Does that, if you get out on that probable cause hearing, is the case over?
That is how that works. If the judge says, no, there's no probable cause, that case, they would release you. In most circumstances, that does mean the case is going to be over. There are some exceptions where a prosecutor's office could still pick that case back up, or, maybe they learned something new, or there are several things. It's not a final, closure of the case, but it would result in your release from custody.
I'm going to go rogue here for just a second, because we've talked before about the fact that there are deadlines in cases. There's statutes of limitations in civil cases. Like, for example, if you have a car accident, then you only have a certain period of time to file the lawsuit against the negligent party. But there are statutes of limitations in criminal cases also, right?
Yes, there are.
So give me some examples of how long the DA and the state have to go after you, and if there's a crime that's been committed, and is it from the time the crime's committed, or is it from the time they figure out that a crime's been committed?
It's kind of a known or should have known thing. So the general rule of thumb is from when the time the crime was committed. That's what's going to be the determining factor in pretty much every circumstance. The statutes of limitations, though, for misdemeanors, it's 2 years. For felonies, the broad rule of thumb is 4 years, but in felony world, things get complicated a lot more quickly. There are a lot of exceptions in those statutes for things like if a victim was under the age of 16 or 18, that will extend the statute of limitations from 4 to typically 7 years. And then in much more serious charges, so what we call the 7 deadly charges, things like, murder, rape, armed robbery, all those very serious cases, some of them have no statute of limitations.
Yeah, like murder has no statute of limitations, right?
Correct.
What are the other ones?
So rape, armed robbery, I think is one that doesn't have a statute of limitations. Like I said, these get tricky really fast because sometimes they don't, sometimes they do.
There are exceptions to every rule. We love to say that as
lawyers.
Yes, well,
there are exceptions to every rule. And again, that usually comes down to things like the age of the victim is the most common reason a statute of limitations would be extended.
Yeah, that's true in civil cases too. There's times when somebody gets hurt before they turn 18, then you can get an extension of the statute of limitations.
Right.
And there were extensions for things like COVID also, but
that happened in criminal world too.
Oh, did it? Okay,
did.
Interesting. So we were talking a little bit about the case being bound over and then leaving magistrate court where the bail stuff happens and then going to big boy court, state court, superior court, where they're actually going to try the case. What happens before trial?
A lot, a whole lot. So the first step, once a case is bound over from magistrate court, is the prosecuting office is going to review the file. For felonies, it's the district attorney's office. For misdemeanors, it's the solicitor's office. They are going to determine what charges to actually formally file with the court. So this is one point of confusion for a lot of people. When you get arrested, it's just whatever the officers think should be the appropriate charges. A lot of times they don't change, but a lot of times they do. Once the attorneys actually look at the file. And so they do that by filing what's called an accusation, or in superior court, they would present the case to grand jury, where a panel of people would hear just their side of the story and determine, okay, is there enough evidence to actually charge this person with this crime, and return what's called a true bill of indictment. And that's the actual charging document that gets filed with the court and actually is what you are charged with.
If you're on a grand jury, you got to be prepared to be there for a while, right?
Yes.
How long is that jury duty?
It can vary, but honestly, I don't really know. Grand jury proceedings are secret from defense attorneys. We are, by law, not allowed to be involved.
I feel like my wife was doing it for like a month. It took a long time for them to come in, and she said it was just bang, 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 back to back, police officers coming in. Here's the evidence we have. Here's what happened. Do you think there's enough information here to, indict?
Yep.
And so anytime you're accused of anything that's in superior court, it has to go through a grand jury first?
Not all the time. Usually it does. There are exceptions where they can file, again, what's called an accusation, and that's just the district attorney drawing up the document and filing the charges. And that is allowed on a set list of types of charges, typically less serious stuff like there's like thefts and, again, things where people didn't get hurt, typically, those types of charges, and they can just file that where it never gets in front of a grand jury.
Okay. So what happens next? Let's say there is an indictment or you're in state court and you're proceeding forward. What can somebody expect to happen next?
So once that charging document is filed, that is the starting point of your case in that court. The next step is your arraignment. That'll be your first court date in the court of jurisdiction, and the only thing that happens there is the judge formally informs you of those charges that have been filed against you.
Okay, so that's what we see on the movies. Like you're in front of the judge and say you've been charged with X, Y, and Z. How do you plead?
Not guilty.
Yeah.
99% of the time, that's what happens, of course. So, because at that point, as a defense attorney, I haven't been able to do my due diligence. I haven't been able to actually, dig into discovery, do my investigation, things like that. So I never advise clients to plead guilty at arraignment. It's something that you can legally do, and it does happen. But usually at that point, on the defense side, we have no idea what the case is actually about.
So don't do that. Don't do that. I would think that at this point in time, you'd never have an opportunity to view police body cam. You'd never have an opportunity. You probably wouldn't even have much of an opportunity to speak with your client.
Typically not. Again, jurisdictions are a little bit different in their practices, but most of the time, if you have gotten your discovery, which is all the evidence that the state has that they would present against you, you probably haven't had much time with it and haven't been able to follow up on it very much. And a lot of the time, you don't even get that before arraignment.
Yeah, I should have asked this before, but when is the first time you usually get to talk to your client?
That varies a lot as well. It just depends on at what point they contact a lawyer.
Have you ever been somebody's first phone call?
I have not.
Okay, we can make that happen.
Okay.
Caller, 404 Law Team. Obviously, a family member could reach out and talk about retaining you. After that, do you get a chance to go to the jail and talk to the person? Okay.
Yes.
Obviously, they can't keep you out. If you're the attorney for somebody who's in jail, the police have to let you in.
Yes.
Okay. So you get a chance to talk to them before the arraignment? Yes?
Yes.
Okay.
Yep.
And what kind of stuff do you usually talk about with a client before the arraignment?
So usually what I want to know going into those court dates is their side of the story. Because at that point, if I have even gotten the police reports or anything, that's just one side of the story. And there are oftentimes a lot of things missing from that.
You can't always trust the police?
Shockingly, no.
Okay.
Not always.
No besmirching the boys in blue, but at the same time, we have to defend our clients, and it's important that we get the full story. And sometimes there's a little bit of cheating on the other side.
Sometimes, and the police officers are people. Mistakes are made, or they are also trying to protect the victims or other things like that. And sometimes there's more to the story that we don't learn until after the fact. There's a whole lot of circumstances that.
That's fair.
Yeah.
Sometimes it's an honest mistake.
Yeah. Sometimes.
The only problem is that you don't want to get stuck with somebody else's honest mistake landing you in jail.
Correct.
Okay. So you talk to the client, you get their side of the story, you go to the arraignment, not guilty.
Right.
And then what?
So then we are in that pretrial discovery sort of phase where I am investigating the case. I'm requesting any records if that is something that is needed in that case. I'm talking to witnesses, family members, anybody involved, so I can really learn the full landscape of what's going on. Once we have that information is when we would do things like file motions to suppress, motions to compel, demurs, which are challenges to the charging document, or there's just a whole scope of types of motions that you can file, and it's very case specific as to what you might do.
Well, and of course, you got the rest of the law team behind you with doing open records requests and getting the other documents that we need to get in order to make sure that you've got everything you need to defend somebody.
Yep.
Okay. All right, so you go through pretrial motions. Judge presumably rules on those motions before trial.
Typically, yes.
Typically. And then what should somebody expect when they are getting ready for a criminal trial? What did they have to do on their end, and what are you doing on your end?
So, some of that depends on what the goals of the client are. If we're actually proceeding to trial, there's going to be a lot of collaboration in terms of me going to clients and saying, hey, I need to make sure I can contact all these people. I need to talk to these people. Is there anything else that I need to know? And making sure we've really done that full investigation. I'll prepare clients for what, the whole trial process looks like more once I'm prepped. Another part of it, though, is negotiating, because, the vast majority of cases don't go to trial.
Oh, yeah, let's talk about plea deals for a minute. So, what kind of factors do you take into account when you're making a plea deal on behalf of a client? And, of course, at the end of the day, it's their decision about whether or not they want to plea out, right?
Correct. Yeah, 100% client decision. That is not something that a decision that an attorney can make for a client. Of course, I can give my recommendations, my thoughts that this is a good deal based on these circumstances. It's a terrible deal. We're not going to take that. Let's keep working on it and chipping away.
Sure. It's just like on a civil case, like on a car accident case, an insurance company can make us an offer. And even if it's millions of dollars, we can't just say, yes, we're going to take it. We have to talk to our client first and say, hey, here's what the offer is. Here's what you're going to net at the end of the day. And just like with a civil case, the client's the one who has to live with the outcome.
Yes.
And so, the most important thing to us is making sure that the client is happy with the result that they get, regardless of what that result is. And, in a criminal sense, I would imagine that a happy outcome is not always possible. The question is just, how good or how bad can we do based on the evidence that we have? And so we have to get somebody the best possible outcome, working within the confines of the reality of what happened.
Yes, and weighing it against the risk of, okay, our other option is we go to trial. What's the risk we face there? And the trial tax is very real.
Yeah, with a jury making a decision based on, a jury being the people who couldn't get out of jury duty,
Yes.
Fine Georgia folks, and we love them. We love our juries, but at the same time, that's a group of people that doesn't know you, who's going to make a decision about
guilt and innocence.
And
then
what's going to happen for the rest of your life.
Right, and then the judge then has full discretion within the confines of course, the sentencing statutes to sentence you however they feel appropriate. At that point, there's no negotiating. I get to do a sentencing hearing where I would argue and present evidence in mitigation to try to persuade the judge to impose a lesser sentence. But typically, a plea deal that is presented as part of a negotiation is going to be way, way, way better than what the judge would impose following a trial.
Okay, let's talk about something fun for a minute. What's your favorite not guilty? Tell me about the story that you have that comes to mind first when you got a not guilty verdict for somebody and it really mattered to you.
So this was while I was still a public defender in Clayton County. I had a client who was accused of aggravated battery. So she was alleged, the state's charge was that she was alleged to have thrown a pot of boiling oil on her younger cousin, and that child was burned very, very, very badly.
That's awful.
It was terrible. Our defense and what I truly believe happened in the case, and the jury did ultimately agree with me, was that it was an accident. And it was. The kids were walking. So my client was babysitting some of her younger cousins, and they were walking through the kitchen, and they ran into each other. And the oil spilled on the child. And, of course, we're not disputing that the oil was spilled, that child was severely injured, that this was a very tragic incident. But she was charged with aggravated battery and went through the whole trial process.
Can you even imagine being in a situation where there's an accident at home and all of a sudden the police are arresting you, telling you, that this is a situation where you're going to go to jail for an accident? I mean, as a father, somebody with two little boys, I can tell you that accidents don't only happen, they happen all the freaking time.
Yeah. Absolutely.
My son put his hand on the stove and really burned it badly.
Yeah.
Ended up with a huge blister on his hand. And I can only imagine what it'd be like if the police showed up at my house and arrested me, saying that I had done it to him, or that, it was a situation where I should have been watching him more carefully. I wasn't home at the time. It was a situation my wife had to deal with. But, fortunately in the situation we're in, we never really run into to that kind of thing.
Yeah.
Being white middle class parents in the suburbs. But I can only imagine what it would be like to have the police show up at my house and how important that would feel to me as the lawyer, getting to not guilty on that.
Oh yeah, absolutely. And this is this young girl had no history, had never been in trouble before. She was really just trying to step in and help her family, and so that was a win that felt really, really good.
That's awesome.
Yeah.